All right, good evening, colleagues and friends. We're delighted to be hosting you this evening for a wonderful program. We're happy to come together at such a time as we are in, hopefully to expand our capacities for thought and for ethical action. Tonight's event is titled Beyond Woke, Why the Focus on Unconscious Bias Will Not Address Systemic Racism. So let me begin by describing a little bit of the structure of the night together, how we'll be proceeding. I'll be introducing our distinguished speaker, Ann Pellegrini, and we'll speak for a good portion of the time, and then we'll be opening it up for audience engagement through the Q&A function. At particular times, you'll see in the chat some communications, and those are the ones coming from the Psychological Humanities and Ethics team here at the Lynch School of Education and Human Development, and much of it has to do with those of you that are seeking CEs. So let's turn our attention first to what it is we're trying to do here this evening. Over the last year, we've actually hosted several lectures and workshops attempting to more deeply encounter and think about what we are up against and needing to do in the midst of a lockjaw level of stuckness with regards to racism and its effects. Dara Cook and Sheldon George spoke to us about the pleasure of hating. Miriam Jernigan-Noisi about the very traumatic effects of racism. Homi Bhabha, quite recently, about the ways that the temporal and traumatic relate within systems of racism. Tonight, we take this up from yet another angle, and it sure takes a lot of angles to attempt anything near the truth. So we'll be doing this with someone that I believe to be one of the great moral imaginaries of our time, a dear friend and a brilliant being. Now let me introduce Ann in a more formal way. Ann Pellegrini is Professor of Performance Studies and Social and Cultural Analysis at NYU. Ann's books and articles traverse several disciplines and interdisciplines, but one through line is an abiding interest in exploring how feelings are lived, experienced, and communicated between and across bodies, and with what risk and possibilities for self and others. Another of her interests is the value of the aesthetic for repairing democratic social life. Ann has written extensively about religion, sexuality, and public life in the US. Publications include Performance Anxieties, as well as the co-authored books Love the Sin, You Can Tell Just by Looking, and 20 other myths about LGBT life and people. Ann is also the co-editor of the journal Studies in Gender and Psychoanalysis. Most recently, and quite excitingly, Ann became a licensed psychoanalyst. Ann is a close friend to the psychoanalytic community, bringing her leadership and scholarship to its conversations and inviting creative, fruitful, and meaningful exchanges. Lastly, Ann is the mixer of the perfect cocktail, a playful and energetic soul who can break into song at any moment or cut to the critical heart of a matter with the sway of an exceptionally illuminative mind. So with all that, let me hand it over to Ann. Thank you for being here with us tonight.
Thank you so much, David, for that incredibly lovely introduction. And I'm only sorry that we're not getting to lift a cocktail together, maybe while I'm speaking, if not afterwards. It's really a joy to take part in the Psychological Humanities and Ethics lecture series, and what an amazing set of conversations you and your team have been setting in motion. Let me give a special shout out as well to two members of that team, Muki Manalili and Daria Magakan, who've worked to make sure that the tech is up and humming for our presentation this evening. Although, as I said, I'm really sorry we don't get to be together in person. I'm thrilled to see so many people in the Zoom room and from far-flung spaces and time zones. It's an indication, I think, of the real hunger to think together and have searching and often difficult conversations about race and racism. And I know that I'm grateful to have the chance to speak this evening about the limits of unconscious bias as a frame for understanding and combating systemic racism. All right, so let me lay out what I'm going to do here. My formal presentation is around 50 minutes. And then, this means we should have about half an hour together for questions and discussion, which I'm really looking forward to. My presentation will be organized around close readings of some legal texts, and I'll intermittently share my screen with you so that you can better follow my discussion of these texts. So here's the first legal text. Let me get the share screen working. All right, so you should be seeing that on a full screen now. Okay. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit or unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe or disbelieve, and how we make important decisions. I'm here quoting Judge Peter Cahill's instructions to the jury on April 19th of this year in the trial of Derek Chauvin. Judge Cahill devotes one full page out of his 14-page jury instructions to a set of cautions about implicit or unconscious biases. This section runs from the middle of page 12 to the middle of page 13 and is marked off under the subtitle Implicit Bias. The previous 11 pages have included a setting out of the duties of judge and jury, extensive explanation of the 3 counts against Derek Chauvin with a legal meaning of particular terms in those counts, the definition of other words and phrases. The jury has been instructed in the presumption of innocence, the principle of proof beyond a reasonable doubt, the meaning of direct evidence versus circumstantial evidence, the role of expert witnesses and factors in assessing their credibility. Jury members are reminded by the judge that they have been allowed to take notes throughout the trial and are even allowed to take them into the jury room, but they are instructed to rely on their memories. The notes should be used as an aid to memory, Judge Cahill tells them, and not as a substitute for it. And it is right here, after instructing them in the use of notes and their relatively lesser weight in relation to memories, that the judge introduces the concept of implicit bias. This section of the charge to the jury constitutes the only explicit instructions he offers them in how to deliberate in order to reach a verdict. We might even hear this part of the jury instructions as directly related to what he has just told them. Rely on your recollections. But how, after all, can the jury members reliably do that when how we remember what we see and hear may be shaped and corrupted by biases the jury members may not even know they have? Controlling for the role of biases is critical if the jury is, in the words of the judge, to make a fair decision based solely on the evidence, their individual evaluations of the evidence, their reason and common sense, and these instructions. Okay. So Judge Cahill offers 4 guidelines to the jury for eliminating the impact of biases, both those we are aware of and others we might not be fully aware of. And you can see them here on your screen. Take the time you need to reflect carefully and thoughtfully about the evidence. Think about why you are making the decision you are making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender, gender identity, race, religion, or sexual orientation, would you still view them and the evidence the same way? Listen to one another. You must carefully evaluate the evidence and resist and help each other resist any urge to reach a verdict influenced by bias for or against any party or witness. Each of you have different backgrounds and will be viewing this case in light of your own insights, assumptions, and biases. Listening to different perspectives may help you to better identify the possible effects these hidden biases may have on decision-making. And finally, resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or unconscious biases. Judge Cahill's jury instructions are both utterly ordinary and remarkable. They are ordinary because, as legal scholar Linda Hamilton Krieger explains, in any individual case involving social interaction, perception, or judgment, judges and juries use implicit psychological theories to perform a variety of functions. The functions include assessing the relative credibility of evidence, drawing inferences from facts, and crafting jury instructions. Krieger, a leading figure in a school of legal theory called behavioral realism, also calls these implicit psychological theories naive theories. Krieger and other exponents of behavioral realism point out that legal decision-making inevitably draws on behavioral theories of human motivation. And given this, it's important that these behavioral theories, especially in the case of anti-discrimination law, which is the focus of Krieger's work, it's important that these behavioral theories, quote, be periodically revisited and adjusted so as to remain continuous with progress in psychological science, close quote. Judges are already intuitive psychologists, in Krieger's words. And if they're going to play judge-doctor, and this is philosopher Michel Foucault's term, not Krieger's, I'll come back to this term. If judges are going to assess human motivation and play judge-doctor, then Krieger wants their psychological theories to be empirically robust and consistent with advances in social psychology, right? But how do insights from social psychology make their way into case law? Now, and case law is law that is crafted through judicial opinions rather than regarding particular cases, rather than say through legislation, right? So case law is law that is crafted through judicial opinions regarding particular cases, right? So social psychology can enter into case law when social psychologists serve as expert witnesses in a particular case, or when amicus briefs are submitted that cite literature in social psychology. Judges may then cite social psychology in their decisions, providing a soft entry point, that's Krieger's term, a soft entry point for these non-legal claims to enter the law as precedent for future citation by other courts. Some vocabulary and insights may even start to become part of a new legal common sense, floating free of the initial footnotes, so to speak. And that is even what seems to have happened in Judge Cahill's instructions to the jury when he mentions implicit bias. And this is the remarkable part about Judge Cahill's quickie tutorial to the jury. Neither the language nor the concept of implicit or unconscious biases is native to the law, but involves an ongoing hybridization of law and psychological sciences, Krieger's soft entry points. The jury instructions in the Chauvin trial evidence this insertion. But the interpenetration of law and the psychological science, or better put, almost the interference or the coming into law of the psychological sciences dates back to the 19th century. This at least is an account provided by Michel Foucault in work in both Discipline and Punish, his 1975 book, and then a series of lectures he gave at the Collège de France on abnormal in the spring of 1975. And what Foucault means by referring to the judge-doctor is to refer to a kind of what he calls a kind of doubling of the crime. So alongside the actual criminal offense, which is being assessed, did this person do it or not, comes the question, and here psychiatric expert opinion is so crucial. So alongside the question of the offense, did this person do it, is the question of what kind of person is this that would do such a thing? Psychiatry, right, introduces alongside, or we could even say better, beneath the criminal act as a kind of depth psychology. It introduces alongside and beneath the criminal act the possibility of discovering a way of being, a social type, the kind of person disordered enough to commit crime X, right? So the psychological doubling of the crime is matched by a kind of a doubling of the functions of the judge, who will not simply be dispensing justice. The judge will, through the aid and advice and expert counsel of the psychiatrist, also be dispensing a diagnosis. This is going to be important as we think about some of the strange futures of such a judge-doctor in anti-discrimination law after Brown v. Board of Education. Now, there is much more to be said about Judge Cahill's gloss on where implicit bias comes from. He emphasizes automatic neurological processes. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. He personalizes and individualizes bias. The social drops out. We look at others and filter what they say through the lens of our own personal experience and background. In his use of the first person plural we, and in his reference to the wiring of our brains, Judge Cahill makes clear to the jury that it is not just about them. He too is one of those affected by this hard wiring. He is one of us. But this reference to hard wiring also has a kind of exculpatory effect. Biased, your brain made you do it. But the bad news of neurobiology is countered by the good news of introspection. We can all also become aware of how we individually do this and can work to sort of hack our hardwiring and minimize the effects of our implicit biases. That such biases need to be eliminated is what we all, or most of us, would agree to. The question of this paper is whether we can, by the sheer force of will or insight, do this. I'll come back to this question. Now, for the specific purpose of jury deliberations in this specific trial, jury instructions are always given in the specific instance, not as a generalization, right? So for the specific purposes of jury deliberations in this specific trial, Judge Cahill's framing of implicit bias, where it comes from and who has it, is important. The jury cannot feel condescended to or chastised. And it is also the case that the jury instructions are among the things that will be the focus of appeals by Chauvin's legal team. This is so in any appeal of a conviction, criminal or civil. The legal team for the convicted party examines the jury instructions for legal errors. Judge Cahill knows this, and his need to make sure he does not commit any legal offense in his jury instructions shapes what he does and does not, or perhaps what he does or does not say, or perhaps better, what he cannot say to the jury. For example, consider the one concrete example that he does give to the jury of implicit bias, which concerns gender stereotyping. He says, one common example is the automatic association of male with career and female with family. Now, in a case that many observers believe has a lot to do with racism, and where we heard coded racial references from the defense with its references to George Floyd's extraordinary strength as he kicked away the officers trying to arrest him. All right, so the psychoanalytically inclined among us may find Judge Cahill's choice of example bizarre, off the point, and even to be a kind of symptomatic erasure or disavowal of the facts at hand. Why is he talking about gender stereotyping in a case that seems so fundamentally to pivot around questions of race? Certainly, racialized masculinity, but where is the race in this example he gives to the jury? But such a psychoanalytic reading, even as the judge alerts the jury to bias, he's himself erasing race, right? This psychoanalytic reading would actually miss the legal point. Had Judge Cahill given an example of racial bias as his leading example of the implicit bias at work, this could in fact serve as grounds for Chauvin to appeal his conviction, because Chauvin's lawyers could argue that the judge was leading the jury to infer that racial bias played a role in the actions of the defendant, something that was not in fact explicitly introduced into evidence in the trial. Hence, I think, the example of implicit bias being one to do with a kind of race-neutral gender, as if there's any such thing as race-neutral gender. Now, some of the limitations of Judge Cahill's gloss on implicit bias may thus be due to the exigencies of the law, what he is required not to say. But some of these same limitations, the depoliticizing and individualizing aspects of implicit bias, as he explained to the jury, are actually, I'd argue, baked into the concept of implicit or unconscious bias. And it's these very limitations I want to suggest that may make them insertable into US law in the first place. That is, US law is amenable to the insertion of a notion of implicit bias because it's already drained of a particular kind of politics. It's already individualized and so fits the notion of liberal subjectivity. Krieger and other advocates for behavioral realism believe that making law consistent with the most recent thinking in social and cognitive psychology will help law to ameliorate discrimination. But my own worry is that the ways that modern psychological science and psychiatry enter the law may actually serve to reinforce discrimination and structural inequality. These concerns are not mine alone, nor are they recent. For example, let's turn to Brown v. Board of Education. This is the landmark 1954 Supreme Court case that held that segregated schools violated the 14th Amendment guarantees of equal protection. Chief Justice Earl Warren, writing for unanimous court, and a unanimous court with an opinion written by the Chief Justice signals that the court believes that the opinion they're about to give, the opinion they are giving, is of urgent importance. The signature of the Chief Justice, a unanimous court. This is like big, bold underlining of the opinion, right? So Chief Justice Warren, writing for unanimous court, cites Kenneth and Mamie Clark's famous doll studies these dolls in which both white and black children are given two dolls to choose from, a black doll and a white doll, and they're told, show me the doll that is pretty, nice, and you want to play with, right? So Warren cites Kenneth and Mamie Clark's famous doll studies to underscore the negative psychological and educational effects on black children. Segregated schools generate a sense of inferiority, in Warren's words, in black children, which, quote, affects the motivation of a child to learn. Segregation, with the sanction of law, therefore, has a tendency to retard the educational and mental achievement of black children and to deprive them of some of the benefits they would receive in a racially integrated school system, right? And you can sort of see the block quote from the page right now, and that's what I just read to you from this block quote. Here, the court is citing a passage from a lower court in Kansas. So Brown v. Board of Education actually is brings together three court cases challenging the practice of legally segregated schools, right? The case out of Kansas is the case that lends its name to this trio of cases, Brown v. Board of Education. And so at this moment in the opinion, Warren is citing the lower courts in Kansas, right? So the cases make their way up to the Supreme Court through lower court adjudication, right? So what's fascinating is that the lower court in Kansas, in its opinion, points to the negative impact of segregation on black children, even as that same lower court upheld segregated schools, doing so on the basis of Supreme Court precedent in Plessy v. Ferguson from 1896. So basically, the Kansas court says, look, there's the evidence that segregated schools are actually work to the detriment of black children, but we actually can't do anything about that because the law of the land says that separate but equal is constitutionally permissible, right? The lower court is bound by Plessy, right, which is one of the most notorious rulings in Supreme Court history for the way it upheld racial segregation and enshrined separate but equal in the law. The Supreme Court in Brown overturns Plessy and removes constitutional cover for separate but equal. And I do want to stress this, it removes constitutional cover for separate but equal. But the actual practice of segregation in public schools continues. Here we are, nearly 70 years after Brown. And in fact, the segregation of public schools is about the same today, percentage-wise, as it was in 1954, right? So you might not be able legally to require segregated schools, but in practice, it continues, right? So the court in Brown overturns Plessy, removing constitutional cover for separate but equal. And the court underscores the distance between then and now, between 1896 and 1954, in part by drawing on the authority of modern psychological science. After quoting the passage from the Kansas court about the sense of inferiority conveyed to black children by segregated schools, Chief Justice Warren writes, quote, whatever may have been the extent of psychological knowledge at the time of Plessy v. Ferguson, 1896, the finding is amply supported by modern authority. And this modern authority has a list of names attached. Footnote 11, which occurs at the end of the sentence, cites first and foremost Kenneth Clark, right, his study effect on prejudice and discrimination on personality development. As you can see, the ordering of citations in this footnote is neither chronological nor alphabetical, which invites us to see the order of citations as indicating the order of importance given to the cited works by the court. I'm going to say a little bit more about the actual controversy that this citation of social science, of social psychology created in legal analysis of Brown v. Board of Education. But before doing that, I do want to just mention something else. I think this is very important, that Brown v. Board of Education is considered a landmark case, right? A sort of a towering case in the history of Supreme Court jurisprudence, and an example that is often given as showing us the kind of forward march, the progress narrative of not just legal jurisprudence in this country, but of the American narrative altogether, that whatever the faults, and they were many, right, of our founding, where the promise of liberty and justice for all, how exclusionary it was, still this is forward march in which we come to include more and more people who've been left out, right? So that Brown would fit into that. But one of the things we want to keep in mind, and here I'm mindful of something that Derek Bell talked about in the 1980 essay. Derek Bell is considered to be like the founding father of critical race theory. Bell talks about in a 1980 essay on interest, the dilemma of interest convergence, and something also that the legal scholar Mary Dudziak has talked about in a really wonderful piece about the Cold War context of Brown v. Board of Education. All right, that Brown v. Board, 1954, what's happening in the Cold War? Segregation and racial strife in this country was making us look bad. So in the Cold War context, where the Soviet Union and the United States are vying overseas for basically client states, courting other countries to align themselves with us or against us, with the West or with the Soviet bloc, right? America, as shining beacon of democracy to the world, looked pretty bad. So part of what's happening in Brown is that the court is aware of this, right? There's a worry about how the United States is looking overseas, right? So Brown, the decision in Brown commands the unanimity of the court, is also about shoring up the standing of the United States internationally. And you'll see this quote on the page on this slide from Roscoe Drummond. This is discussed in Mary Dudziak's piece, but basically after Brown, right? And so here's Drummond writing in the European edition of the New York Herald Tribune, and this is important. So Drummond is addressing Europeans, right? This is to speak again about the international policy in which Brown is inscribed, right? The US Supreme Court has given a new definition to un-Americanism. It's ruled that segregated schools are unconstitutional and therefore un-American. So that, again, this Brown has to be seen as advancing US interests abroad, even as, you know, there may well have been the moral mandate the court is advancing to address racial discrimination. It has this other story too, which is about the picture of the US to the world. So it's also about enforcing a picture of a US nation that is still caught up in whiteness, right? We want to think about, this is Derek Bell's analysis of interest convergence. Brown, why did Brown command such support from the white legal establishment, for example, or from white politicians? In part because it serves white interests too. And this is something, as he grows increasingly pessimistic about the promise of civil rights legislation and of Supreme Court jurisprudence around discrimination, part of that pessimism has to do with what happens when there isn't a convergence between the interests of fighting racism and whiteness. Where there is a convergence, maybe you get policies that are trying to end discrimination, but where there isn't that convergence, maybe you get more of the same. That is the history of white supremacy. All right, I'm gonna stop my screen sharing for now. So I wanna turn now to some of the controversy to do with the court's use of social science, of social psychology, and that famous footnote number 11. As legal scholar Stephen Rich notes, in the eyes of many legal scholars who were otherwise supportive of Brown, the court's citations to social science undermined its integrity. For example, Edward Kahn, writing in the NYU Law Review the same year, basically the year after Brown, worried that if Brown indeed turned on social science, that the guarantee of equal protection might be seriously restricted to those cases in which the plaintiff offered proof or could offer proof of permanent psychological damage, right? So you locked into having evidence to hand, right? That's one important question, right? And in his quick, but by no means exhaustive survey of some of the concerns voiced by legal commentators over the Brown Court's invocation of psychological studies, Rich also mentions early worries that footnote 11 of Brown was a mistake that left Brown vulnerable to the charge that it was unjudicial and illegal. And it's worth noting that this charge, that the law is improperly introducing authorities beyond the law into the law's reasoning, is precisely what advocates of behavioral realism are calling for, namely to advance the law's fairness by introducing advances in modern psychology into it. Now, to my mind, though, the chief drawback of the court's turn to the social psychology of inferiority and self-esteem in Brown is that this turn inwards to the interiority of the self has inadvertently contributed to the notion that what's at stake in racism and in the racial segregation that is one of its expressions is the self-esteem of individuals, their internalized sense of themselves, rather than unjust social relations and the material conditions through which racialized inequalities are produced and reproduced. This worry, right, that there's a kind of like smokescreen of psychology, right, and of the internal that makes it impossible to see social structure, right? This worry was expressed early on by Charles Black Jr., a scholar of constitutional law. Charles Black was among those who helped future Supreme Court Justice Thurgood Marshall, then with the NAACP's Legal Defense Fund, to write the legal brief for Linda Brown, the African-American schoolgirl from Topeka, Kansas, who lent her name to Brown v. Board of Education. In a 1960 Law Review article reflecting on Brown v. Board, Black argues that, quote, school segregation is unconstitutional, not based on a metaphysics of sociology, that is, on a sense of inferiority and its impact. It's unconstitutional because the social meaning of segregation, Black continues, is the putting of Black people in a position of walled off inferiority, right? So it's unconstitutional because of what it does, what is it embedded in, right? Now, it's not that we should not be concerned with the felt experience of racialized inequality, but that there's a risk of overly psychologizing its harms and looking away from its material effects and social reproduction. And it may be that the mirror image of this psychologization of the injury of harm seen to be damage to self-esteem, right? It may be that the mirror image of this psychologization of the injury of harm is the idea that for there to be a racial injury to someone, the person harmed, you must be able to point to agents, to subjects who intentionally perpetrated this injury, and you must establish that they did so due to prejudice. But this is partly what studies on implicit bias were meant to counter, at least it seems so, namely the idea that biased actions were always or only due to consciously deliberated actions. Now, implicit bias studies do not give up on establishing intentions. Instead, they depth psychologize them, looking beneath consciousness for biased motives we didn't know we had. To underscore, this is not the same thing as unintentional discrimination. And it's even further from helping us understand or legally cognize systemic racism, whose ongoing force cannot so easily be pinned down to individual subjects motivated, whether explicitly or implicitly, by bias. And there's another problem here. Title VII of the 1964 Civil Rights Act, right? Title VII, which is what makes possible legal challenges, for example, to workplace discrimination, right? On the basis of race, religion, gender, nation, right? A plausible reading of Title VII of the 1964 Civil Rights Act is that one is looking for discriminatory effects. One is not required, and again, this is a plausible reading of this act, and it has in fact been a reading that the court earlier adopted. It's moved away from this, but it is a plausible reading to say that you look not for, you don't have to prove intentional motives of someone intentionally to discriminate. You show rather that a law or policy has discriminatory impact, right? Now, the focus on implicit bias brings into the adjudication of discrimination cases looking for motives. It sneaks intentionality in, whether it's an intentionality you knew you had or you're to scratch harder for, right? And the court has in fact been going a hard right in that direction. It's only discrimination if you can prove discriminatory intent, right? Now, Brown predates, Brown v. Board of Education predates the coinage of the term implicit bias by roughly 40 years. The term is generally credited to psychologists Mahzarin Banaji and Anthony Greenwald and their 1995 book, Blind Spot, Hidden Biases of Good People. But even if you haven't read their book, you may be familiar with the implicit association test, or IAT, that was designed by Banaji, Greenwald, and their colleague, Brian Nozick. 1995 was also the year that Krieger published her first legal essay calling for greater integration of contemporary advances in psychological knowledge about human behavior into anti-discrimination law. Her essay was entitled The Content of Our Categories, a cognitive bias approach to discrimination and equal employment opportunity. 8 years earlier, in 1987, Charles Lawrence III introduced the notion of unconscious bias into legal theory with his influential 1987 paper, The Id, the ego and equal protection, reckoning with unconscious racism. And this essay has become a classic of a legal movement known as critical race theory, or CRT. I'll be saying much more about CRT momentarily. In that essay, Lawrence speaks of unconscious racism in two ways. He draws on Freudian ego psychology, and he also turns to new developments in cognitive science. Now, first, these are very different languages and models for talking about and theorizing the unconscious. One of them, a psychoanalytic language, a psychoanalytic model, has scarcely been spoken since in the legal literature. Much to Lawrence's own chagrin, what was taken away from readings of his essay, and I have to say, this is considered to be one of the most influential essays in legal history. It's ranked number 60 on the list of most cited American Law Review articles of all time, right? But what was taken away from readings of his essay is a focus on the way that individual actions may be motivated by bias individuals are unaware of. And this was not his main interest, all right? And this is my second quick point about his essay. He wanted to pivot from making a case for unconscious racism of individuals to identify the origins of such individual bias in a kind of shared cultural unconscious. And were we to speak in a different psychoanalytic register, perhaps we could think with Laplanche and think about the mythosymbolic, right? What's available to format the unconscious, right? So he wanted to pivot from making a case for unconscious racism of individuals to identify the origins of that individual bias in a kind of shared cultural unconscious, a shared cultural unconscious that comes about in part due to the ongoing history of racial insubordination and the way that this racial insubordination has been reinforced through shared cultural meanings of white supremacy, but of a white supremacy that is irreducible to individual intentions. This is not about finding, some white guy or group of white guys, founding fathers even, and say, oh, they're the reason for all of this. And if we could, white supremacy lives in us. In some sense, it precedes subjectivity. It's part of its formation, right? So again, he wanted to think about shared cultural meanings of white supremacy irreducible to individual intentions. Right? Lawrence's innovative attempt to mobilize a psychoanalytic vocabulary to prompt legal thinking and remedies for the societal disease of racism has not only not been taken up by the courts, it was read past by many, if not most, readers of his 1987 essay. Unconscious racism, at that term, is invoked in subsequent legal articles and in diversity training workshops, speaks the language of cognitive psychology, and professes the can-do spirit of American individualism. Work hard, think hard, feel good, you too can undo your habituated prejudices. We're in the train of implicit bias. And if we were to use a psychoanalytic vocabulary here, it would be about a preconscious, not an unconscious. But unconscious bias, but really what it means is a kind of preconscious bias or implicit bias. Unconscious bias or implicit bias training has nonetheless become ubiquitous over the past 2 decades, with some version of diversity training adopted at most major US companies and at college campuses nationwide. But this training has a still earlier history that precedes the 1990s. The civil rights movements of the 1950s and 1960s prompted some US companies to introduce anti-bias training. And the effort gained traction at government agencies too in the 1970s. For example, by 1971, the Social Security Administration had put 50,000 workers through racial bias training. And the adoption of anti-bias training in private companies and in federal and state agencies was spurred by new anti-discrimination laws, right? So again, under Title VII of the 1964 Rights Act, which I mentioned earlier, right? So under Title VII of the 1964 Civil Rights Act, private companies, unions, and employment agencies were barred from discriminating on the basis of a number of things, but race, which is most salient for the conversation we're having this evening. And then in 1973, Congress amended Title VII so that it would apply to the entire federal government, and therefore the entire federal workforce, and that also extended Title VII to apply to state and local agencies that employed more than 15 people, right? So again, diversity training goes back, well before the 1990s. We can sort of see this move in the 1950s, 1960s, 1970s, which is responding to growing anti-discrimination laws. So companies and state and federal agencies want to be on the right side of the law, right? So, but then we could go back even further. And I think this is really important to think about in the context of neoliberalism. The workshops to address bias in the workplace are also drawing on an earlier set of workplace practices that have to do with human resource management. As early as the 1920s and 1930s, a whole new management science was growing up, which was trying to figure out how to adjust workers, not to coerce them, but to adjust workers to the ways in which they were fitting into industrialized workspaces and into also like white collar workspaces. How do you adjust them, right? How do you manage that most precious resource, which is human, the human worker, right? So think of the language of human relations. We have human resources departments, we have human relations departments in lots of large scale organizations. And they start developing workshops, right? Workshops to help the workers get along, right? And this sort of starts developing in the 1950s and 60s into sensitivity training, not yet anti-bias training, but this provides some of the energy for the later development of anti-bias workshops. And again, I really want to emphasize, it has one of the genealogies of the diversity training we're so familiar with today, right, is human management science and the interest in producing the right kind of worker who will get along with coworkers. And as you start to have, in the wake of Brown and in the wake of a subsequent decision in the 1950s, this is the decision having to do with the Montgomery bus boycott. So actually that sort of a set of laws and court decisions that are doing away with legal segregation. You're now integrating workforces that were previously segregated. Now you have to deal with workers getting along, not just, sort of, everyday human relations. This, how well do Joe and Jim get along? But now you have to think about how basically white workers are responding to a newly integrating workforce. So now alongside human relations is the question of race relations. But both are being subject, again, to this notion of a kind of administering, like this human management system, which is about administering workers, right? And we really need to think about this because in the neoliberal context within which diversity training is operating at companies and at universities nationwide. All right. I'm happy to talk more about this in our discussion period as well, right? All right. So again, long history to diversity training. It's there, going back at least to the 90s. Before that, we have a prehistory of it. So what's going on now, right? Why the attack on diversity training, the ferocious attack on it now? Arguably, in the wake of the May 2020 murder of George Floyd and the nationwide protests against anti-Black racism that it ignited, and to which more and more white Americans were paying attention. Why? Because so many people were at home because of the pandemic, at home, observing social media, right? There were more white Americans tuned into the 1920 incarnation of Black Lives Matter than had tuned in during when Black Lives Matter first emerged, right? And actually, when many white Americans tuned in as Black Lives Matter emerged in the wake of the murders of Trayvon Martin, for example, or of the death of Michael Brown, right? A lot of white Americans tuned in and got turned off, right? But something else is happening in May of 2020, right? So we have the murder of Floyd, the nationwide protests against anti-Black racism that ignited the different ways in which white Americans were tuning into that, right? So now in September 20, right? So that's May of 2020 is the murder of Floyd, series of protests over the long summer and into the fall. In September 2020, both unconscious bias training and critical race theory come under ferocious attack from the Trump administration, which issued an executive order that conflates CRT, critical race theory, with diversity training and bans unconscious bias training at any workplace in the US that received federal monies. And this ban effectively means you can have no diversity training at any college or university in the country because basically every college and university in the US gets federal monies. Now, this executive order was effectively canceled by President Joe Biden as one of his first executive actions. And yet I'm going to spend the next long section of this talk on a close reading of Trump's executive order. But why do I do this? It's no longer legally efficacious. First, what Trump said and still says, and what his administration did, are not singular instances of racism. On the contrary, Trump openly exposes, present tense, a sensibility that runs through so many aspects of American life, actively shaping institutions of governance up to and including the Supreme Court. There is thus something exemplary rather than exceptional at work in Trump's executive order. Second, even though President Biden overturned this executive order as one of his first acts in office, versions of it have been passed into law in Idaho, Oklahoma, Tennessee, Texas, Iowa, New Hampshire, Arizona, and South Carolina. I need two hands, and actually soon I'm going to need three to count out all the states, because these are just the states where this legislation had passed by August 13th, 2021. It's pending in a bunch of other states with Republican-controlled legislatures, right? Now, of the legislation that has passed so far, only Idaho's mentions critical race theory by name, right? But as Rashawn Ray and Alexander Gibbons of the Brookings Institutes explain, all the state laws in question effectively, and now I'm quoting Ray and Gibbons, all the state laws in question effectively, quote, ban the discussion, training, and or orientation that the US is inherently racist, as well as any discussions about conscious and unconscious bias, privilege, discrimination, and oppression. These parameters also extend beyond race to include gender lectures and discussions, close quote. Strikingly, and I've been reading this legislation across the states in which it is thus far passed. Strikingly, the same wording appears verbatim over and over in these state laws. For example, Oklahoma's version states that, quote, no teacher, administrator, or other employee of a school district, charter school, or virtual charter school shall require or make part of a course the following concepts. One race or sex is inherently superior to another race or sex. Two, this is the other concept you can't teach. An individual by virtue of his or her race or sex is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Right, the law goes on and on, but this is the passage I wanted to pull out from Oklahoma. Compare this to Texas's newly passed legislation, which says that, quote, no teacher, administrator, or other employee of a state agency, school district, or open enrollment charter school may require or make part of a course the concept that, here we are, number one again, one race or sex is inherently superior to another race or sex. Two, an individual by virtue of the individual's race or sex is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Verbatim, the same language as appears in the Oklahoma law. And as we shall shortly see, these divisive concepts, these are some of the divisive concepts you can't teach. All of these divisive concepts appear in the Trump executive order from September of 2020. And this is more than coincidence. The Trump executive order was a road test. So it was actually exemplary in a very direct way. Groups like the Heritage Foundation, the Concord Fund, and Montana's 1776 Foundation have all been drafting model legislation to fight a problem that doesn't actually exist, but no matter the facts. Republicans hope to ride the controversy over critical race theory and the divisive concepts supposedly being taught in its name, even when the name critical race theory isn't mentioned by name. They're hoping to ride this controversy into a Republican majority in the House and Senate in the 2022 midterms. Recently, we saw the way in which this controversy was weaponized in the Virginia gubernatorial race. Some even have been suggesting that Glenn Youngkin's victory, the Republican candidate's victory over Terry McAuliffe, the former Democratic governor of Virginia, that Youngkin's victory was made possible by the controversy, right? So that Youngkin's basically saying, my first day in office, I will ban critical race theory. Now, it's actually ambiguous if the controversy over CRT is the reason that Youngkin defeated Terry McAuliffe. And I think it's important to really stress that it's actually unclear, we don't know. For one thing, the meaning of the exit poll data is not reliable. But second, and this is also really important, that in the history of Virginia gubernatorial elections, it has, I think in the last like 10 or 11 gubernatorial elections, the gubernatorial candidate from the party currently in the White House does not win. So McAuliffe was at a disadvantage because there's a Democrat in the White House, right? I'm saying that there actually all sorts of reasons why McCulloch was at a disadvantage in this race. And it is actually not at all clear that the debate over critical race theory put Youngkin over. And why does this matter? Because the claim is being made, right, on the right, who are thrilled at the idea that CRT is getting the Democrats into such trouble, right? The claim is being made on the right that CRT is so toxic, keep using it as a sledgehammer to beat back Democrats because you're going to win with it. And Democrats are suddenly now, moderate Democrats or at least, are suddenly somehow becoming convinced that this is why McCulloch lost. And therefore, they're also now chastising the woke members of their own party, saying, can you just be a little bit more quiet about racial justice, right? So this, again, it might not even be the case, and it probably is not the case that the debate over CRT put the Republican over the finish line. But the belief that it is now being sufficient for both Republicans and Democrats to make critical race theory more and more toxic, right? It's turning CRT into an all-purpose bogeyman for the excesses of wokeness. And it's doing so, again, on the right, as well as on amongst many moderate and conservative Democrats. Okay, let's turn now to the executive order on combating race and sex stereotyping, which was signed by then President Trump on September 22nd of 2020. Just days earlier, let me pull up the PowerPoint again. All right, here we go. All right, so that should be on a full screen for all of you again. Here we go. All right, so oh, by the way, I have this because this at least makes me happy. Because Trump is no longer president and the executive orders he signed are no longer in effect, any executive order under the Trump administration is now basically archived. So if you actually search for the Trump executive order by name, this is what you'll first get if you go to whitehouse.gov. So you'll get page not found. And that at least makes me happy. At least it tells me that Trump is not currently president. So that's good. But here it is, the executive order on combating race and sex stereotyping. And I want to draw your attention to this kind of fascinating language at the top. Again, I just said this executive order is no longer efficacious because it was overturned by Joe Biden. It was one of his first acts of office in the office of the presidency. So you'll see at the very top of this page, right, that it says this is historical material frozen in time. The website is no longer updated and links to external websites and some internal pages may not work. So frozen in time means basically it again of no longer of any legal effect, but we're keeping these documents that belong to this earlier administration. Frozen in time is really fascinating to think about psychoanalytically, and maybe we can play with that together in the discussion afterwards, right? Now, just days earlier, right? So right before, whoops, let's go back, right? The executive order is issued on September 22nd, 2020. Just days earlier, on September 17th, Trump had given a speech announcing a 1776 commission to teach patriotic education. And here are his words. America's founding set in motion the unstoppable chain of events that abolished slavery, secured civil rights, defeated communism and fascism, and built the most fair, equal, and prosperous nation in human history, close quote. Now, this belief in the inevitability of racial progress and freedom's expansion provides the heroic frame of the executive order on combating race and sex stereotyping. Right. This executive order builds on and extends a memorandum that had been issued just 2 weeks earlier on September 4th, 2020, by the Office of Management and Budget that had effectively banned diversity training at all federal agencies. The EO is that executive order for the one we're talking about, for executive order on combating race and sex stereotyping is thus part of a cluster of coordinated recent attacks on critical race theory, or CRT, an intellectual movement that arose in the US legal academy in the late 1970s and 80s to explain the persistence of racism despite important civil rights victories, such as Brown v. Board in 1954, the Civil Rights of 1964, the Fair Housing Act of 1968. Critical race theory attempts to understand structural or systemic racism, the various ways that racism is built into the everyday life of everybody and into such social institutions and state bureaucracies as law and education. And importantly, the concept of structural racism better explains ongoing racial inequalities than does a focus on the racist acts or racist motives of a few or even a lot of racist individuals. Think, for example, of the disproportionate impact of COVID-19 on people of color. This is an example of structural racism at work. and its deadly effects cannot be traced to the deliberate intentional actions or omissions of a racist individual or group of individuals who alone are to blame. The force of racism pours through and contours the social, forming and deforming individual and group possibilities. And we have to do without angels or devils, good or evil, splittings that psychoanalysis, in any case, teaches us to distrust. Now, Trump's executive order on combating race and sex stereotyping has three stated rationales, and we can see them here. They lead off the executive order. First, right, to promote economy and efficiency in federal contracting. Second, to promote unity in the federal workforce. And third, to combat offensive and anti-American race and sex stereotyping and scapegoating. A few things to note right away. The first, to promote economy and efficiency in federal contracting, sets the tone of the executive order by situating it within the economic and bureaucratic logic of neoliberalism to promote efficiency. Now, bureaucratic organizations are also conductors of structural racism. Again, even well-intentioned individuals can and routinely do devise and carry out policies that have racially discriminatory effects without doing so on purpose. And this is also why being woke is not enough to end racial inequality. Being woke is good, but it's also not enough. The second stated rationale to promote unity in the federal workforce speaks the language of human resources management. With its interest in reducing any static, and human relations are prone to this, right? And with its interest in reducing any static that would get in the way of a workplace's smooth and profitable operation. But it is this third and final stated element to combat offensive and anti-American race and sex stereotyping and scapegoating that gives this executive order its proper name, the Executive Order on Combating Race and Sex Stereotyping. This turn of phrase is what makes this executive order deceptively appealing. I mean, who's going to speak up for race and sex stereotyping? But note too, this important recalibration from combating race and sex stereotyping in the executive order's title to combating offensive and anti-American race and sex stereotyping and scapegoating in the body of the executive order. As we'll come to see, what makes a particular claim about race or sex offensive is that it runs counter to the nation's founding story. And this founding story appears in section 1 of the executive order, purpose. It marches us through a triumphant history of we the people, as always already committed to principles of equality for all people. It's a kind of originalist, all lives matter. And I'm gonna keep this up on the screen so you can read it, right? It's a strange origin tale. It starts at the Civil War of the mid-19th century. It leaps to the Civil Rights Movement of the mid-20th. And then it identifies in both of these a fulfillment of the founder's dream that all men are created equal. And fascinatingly, the heroic Americans mentioned in this passage are all either Black, the heroic Black soldiers of the 54th Massachusetts Infantry Regiment, civil rights activists of Montgomery and Selma, Martin Luther King Jr., or they're in some way allies in struggles for Black equality, such as Lincoln and those who gave their lives in the battlefield of Gettysburg. Unnamed in this text are the forces that required such acts of heroism, the obstacles that heroic Black Americans and their allies had to overcome. That is to say, what's ghosted here is white supremacy. By starting at the Civil War, the executive order leaves out the whole history of slavery. We get a flash of 1776, but left out of here is 1619, the year that the first kidnapped enslaved Africans were brought as property to what would become the United States. Then, by leapfrogging to the Montgomery bus boycott of 1955-56, the executive order story of America rushes past both the extra-legal as well as the legal state-sanctioned violences of Jim Crow. By this rhetorical sleight of hand, anyone who is American is baptized after the fact of our original sin, slavery, genocide, ostensibly uninvolved and unimplicated in the conditions that established the nation. Bathed in the blood of those who fought and died at Gettysburg, and of those who marched and were bloodied from Selma to Montgomery, we Americans are all heroes now. What's more, we are bleached of the stains of the past. Section 1 of the executive order contains 2 references to Dr. King's dream of a colorblind future. It turns out that future is now. having leached out the enslavement of African people from American history and having contorted this history into an anti-racist teleology, it was always already going this way. The executive order insinuates that colorblindness is the end game of anti-racism. And taking us down a rabbit hole of false equivalences, the executive order scrambles not only history, but also our thinking. We're being gaslit by this executive order. Down is up and up is down. This is how we end up with the following perplexing proposition. It is, we are told, opposition to racism and sexism, not racism and sexism themselves, that offend American values, thus necessitating this executive order. The executive order goes on to list certain divisive concepts, and we've already heard them, right, in the state legislation that I quoted to you, but the state legislation came second. They got it from this document and from the model laws being prepared by right-wing organizations, right? So the executive order lists certain divisive concepts that are to be banned from any federally funded diversity training to ensure that this opposition will not be allowed to offend American ideals. These divisive concepts turn out to be any ideas that intimate that racism and sexism are structural, historically enduring, and in excess of any individual's motives or acts. And here is where that recalibration I mentioned earlier, from combating race and sex stereotyping to combating offensive and anti-American race and sex stereotyping scapegoating, right? Here's where that recalibration kicks into high gear. The executive order refers ominously to a destructive ideology grounded in misrepresentation of our country's history and its role in the world. Now, neither critical race theory nor Black Lives Matter is directly named in the executive order, but we know from the larger historical context of the executive order's issuance that its distorted image of one of them, CRT, is being used to discredit the other, Black Lives Matter and other anti-racist activisms and anti-racist thinking more broadly. Although the executive order explicitly names sex stereotyping as an area of concern, in fact, the historical conditions cited to explain the reason for the executive order only pertain to race. No references were made to sex or sexism in the heroic foundation story that leads off the executive order. This may lead one to speculate. One might speculate that concerns over sex stereotyping are just tacked on for added heft, or perhaps to take the heat off racism. In one particularly astonishing passage, critical analysis and teaching about the ways whiteness is built into American law and social institutions are equated to discredited notions of the 19th century's apologists for slavery, who, like President Lincoln's rival, Stephen A. Douglas, maintained that our government was made on the white basis by white men for the benefit of white men. In other words, according to this executive order, an analysis of how white supremacy is structured into US laws, institutions, and everyday life is equated with the white supremacy itself. Put still more bluntly, the institution of slavery turns out to have been critical race theory before the name. The EO cannily, that is the executive order, cannily collapses the difference between using racial categories as a way to analyze and combat discrimination and the use of racial categories to ground discrimination. To name race is itself the preamble to racism. A colorblind approach, the executive order's logic suggests, is more equitable to people of color, who will not have to shoulder the weight of their difference because their difference from whiteness will no longer be called to attention, to the attention that is of white people. In the end, the doctrine of colorblindness comforts white people because it shields them, shields us from having to consider not only other races, but our own racialization. Within the rhetoric of the executive order, this conflation in which calling attention to race and racism equals racism, right? Calling attention to race and racism comes to equal racism, right? This is motored by taming Dr. King's words and activism and insisting we have arrived at the colorblind future he only dreamed of. But what if we take seriously this word dream, right? What if we take seriously this word dream? Thinking and speculating with Jose Esteban Muñoz's conception of queerness and queer utopia as an always receding point on the horizon that we squint to see but never finally arrive at. What if Dr. King's dream, right? What if Dr. King's dream of a time when his children will be judged not by the color of their skin, but by the content of their character, right? What if this is also in a future perfect, a will have been that never arrives? And the struggle towards is the point. We may never get there. What's more, the there at which activists for social justice aim may have to keep shifting because the forces that oppose social justice adjust to conserve power. All right. In the history of sexuality, I'm going to talk about, turn to, I think, another resource for thinking helpfully about sort of the ongoing force of racism, right? In the history of sexuality, Michel Foucault famously asserts that power is everywhere, but so too is resistance. Where there is power, he writes, there is resistance, and yet, or rather consequently, right? This resistance is never in a position of exteriority in relation to power. Right? Now, that this is so tells us nothing about the motives of any given instance of resistance, nor its likelihood of success. In fact, Foucault suggests, right? In fact, Foucault suggests any success is only ever temporary because resistance generates fresh resistance in its wake. Power, to put it differently, regroups. But then again, so does resistance. I know I'm being very abstract right now, but stay with me, right? Foucault offers a picture of relations of power, right? Flexibly responding to fractures in it, recuperating breaks and challenges. So the particular form of struggle, let's say even legal struggle, a particular language that advances, let's say, advances the terms of anti-discrimination, right? That very language that succeeds in one moment could be, once it succeeds, gets taken up, right, into the law or into social policy or into everyday life. But then, you know, in some sense, we could say that power strikes back. We're in a relation to power. There's a flexing back, right? So that there can be an appropriation of a strategy that once worked for resistance, and it could be a pull back towards a conservation. In this instance, we could say a conservation of the logics and power of white supremacy, right? Struggle continues. Victories are not ones for all. And this is something that Derek Bell, again, one of the really considered to be the founder of critical race theory, this is something Bell gives flesh to in a 1992 essay on racial realism, where he points out that racial patterns adapt to legislative and judicial victories in ways that maintain white dominance. Again, we could think about this within this picture of a kind of flexible relations to power where there is a resistance, power then regroups to actually sometimes to recuperate this resistance back into power, back into the workings of social dominance, right? And I think that it's in this context that we might want to think about something really peculiar, right? Something really peculiar about the language of self-esteem, right? I think I'm gonna end here to make room for conversation. Remember I said earlier that in Brown v. Board of Education, the court turns to social psychology literature and identifies as one of the key injuries of racial segregation, the damage to the self-esteem of Black school children, right? Now, this is from the court's perspective, the damage to the self-esteem of Black school children. In fact, the social science literature is a bit more equivocal than some of the literature that was cited in the Brown case. The question of damage to self-esteem, this now sort of surfaces as like somehow this was one of the injuries of racial segregation, but now somehow it's floated as if it's the thing we have to correct. We have to correct for damaged self-esteem. And this is now how it's working. We can think of this as a kind of reverse discourse, a taking up of something that was used as a kind of, as a way to sort of fight discrimination. See the self-esteem of Black school children is being damaged by racially segregated schools. Now the language of self-esteem is being cited by opponents of so-called critical race theory. I say so-called critical race theory because it's actually nothing like critical race theory, but you have people opposed to movements movements that are combating anti-Black racism, people opposed to social changes towards greater inclusion, right? And they're saying, you can't teach my children the history of racism in this country because it would injure the feelings of my white child. So now the language of self-esteem is being used as a reason not to have conversations about race and racism. This is like, in some sense, if it's a hijacking of the language of self-esteem and its identification as a damage, right? It's a hijacking that in some sense was predicted in advance, right? It was always inadequate as a frame. And it also, again, this idea of looking for injuries to self-esteem also gets us caught up in looking into an internal world that is too often cut off from thinking about larger social dynamics, or at least being able to hold on to this interplay between larger dynamics in the social and in the formation of subjectivity. I want to end here because I'm really eager to hear some of your comments. And thank you again for the invitation to speak to you tonight and present some of this new work.
Thank you so much, Anne. That was absolutely exceptional. And I want to invite the audience. We have about 12, 13 minutes. And the best way to do this is to throw your questions in the question and answer function at the bottom of the screen, and we'll see it pop up here, and I will pose the questions to Anne. I know as I was listening to you, I kept thinking, I wish you'd go down this rabbit hole. Oh, I wish you'd give another lecture on this. Oh, CRT as the all-purpose boogeyman. I want to hear more about that. Genealogies of diversity training. Absolutely would love to hear that talk, along with the neoliberal context of diversity training. And then the flexing back of power, appropriations, and conservation. I think that is something so critical for us to be able to keep exploring and seeing the ways that that functions. So I know that those are your next 3 lectures. I just want to,
okay, all right. Yeah. Well, all Foucault all the time with a lot of critical race theory, right?
Absolutely, absolutely. So I see a couple things are coming in here. Self-esteem and concept of microaggression. I'm wondering if you're familiar with Lilienfeld, 2017. Might you comment on his deconstruction of the concept of microaggression and the problems related to validation of such concepts? I'm not sure if that's something that you could take up.
Wow, I don't know that article, and thank you for bringing it to my attention. So I can't comment on that, but I think one of the things I want to say about the question of sort of like microaggressions, I'm not saying that it's not important to sort of note sort of the particular way, the ways in which everyday language, everyday bodily gestures can actually sort of be reinforcing sort of hierarchies of various kinds, right? And that it's worth calling attention to them. But I think it seems to me a mistake to think that this is to sort of put all our eggs in that basket, and to sort of miss the larger sort of picture of sort of the structural. And I think maybe the other aspect here that I'm thinking about is this focus on self-esteem and Brown. Again, I think it's interesting. There's a sense in which the focus on self-esteem and Brown was actually told, even though maybe in Kenneth Clark were African-American sort of psychologists, they were doing this really important work because they wanted to advance the cause of anti-discrimination. I think there's a way in which when the court takes it up, they're imagining this sense of inferiority, so that it's being told from the standpoint actually of whiteness, imagining how Blackness must feel in a racially segregated space. It cannot imagine, right, that being in a Black space could actually feel like solidarity, like could actually feel good and enabling and vitalizing, right? And there are a lot of debates that have been going on for a long, long time about whether or not the move to desegregate schools was sufficient, especially because also, first of all, it never worked, right? We haven't actually desegregated public schools, but that the problem wasn't simply, that schools were segregated. The problem was that there were not equal resources, material resources, flowing to Black school children, right? And their teachers, right? So again, this focus on self-esteem makes that seem like that's what's at stake without seeing the larger material context. And I think maybe there's some link to a particular kind of, maybe this is even something, again, I think we need to really think hard about as psychologists and psychoanalysts. a vulgarization of trauma, a vulgarization of the concept of trauma, such that an injury to self-esteem is somehow seen as traumatic, right? And I don't think that's helpful. I think it actually makes it impossible for us to talk about legacies of trauma in a profound way. It also assumes in advance that we know the meaning of a particular experience of racism or racist violence. And here I'm very grateful to ongoing work from Saketopoulou, who's been sort of making some of these points, which I've learned from.
Great, thank you, Anne. One playful, sweet question that's actually a compliment, and then I'll get to another question that's actually a question. The first playful one is, can you do this as a short version on the Rachel Maddow show? It would be so timely. You're brilliant and articulate. So not a real question, but wanted you to hear it. And
thank you for
then
saying
the
that.
next one, if we should be more concerned with systemic racism rather than looking to blame individual bad actors, what role does so-called cancel culture play? Does holding individuals accountable shift our focus away from the structural forces that we need to be more concerned with? That's an excellent question.
Yeah, it's a wonderful question. Thank you for it. So I think that it's a really good question for the following reasons. I think there's a conflation between canceling someone and accountability. I don't think they're the same thing, right? And I also, I'm thinking about something that after Trump's executive order went into effect in September of 2020, and there's, in the last part of it, it actually says that no part of this executive order can be construed to say that you can't actually introduce some of these issues, let's say, into a college curriculum, so long as you do so in an objective way. But they didn't say what's an objective way to talk about the history, for example, of racism in this country, right? They gave you no guidance about how that was to be adjudicated. And in the wake of the executive order, a bunch of universities either canceled or postponed the diversity training they planned because they were really worried about losing federal monies. And they also canceled outright a number of speeches that were addressing white privilege and whiteness and the social history of whiteness. That's being canceled, right? And it's being canceled because the university was afraid of what would happen to them, the punitive arm of the state, right? That seems to me different from basically saying, I'm no longer interested in what this person has to say, or I disagree with this. Like, who has the social power to do certain things? The university here was being effectively coerced to make this decision to cancel a speaker because of the power of the state. And I think that that holding individuals accountable is important, but and again, it's not the same thing as canceling. I think we need to sort of think about these two things differently. It's great and a great question, and I feel like I haven't done justice to it.
Thank you, Anne. And I know in my courses, so frequently the question of cancel culture comes up, and people feel so deeply uneasy with how it is being wielded. Right. But that distinction you just made between accountability and canceling is so important here. So, but
I'm thinking it's also connected. I'm thinking, and that I'm constantly inspired by returning to Audre Lorde's very important essay, "The Uses of Anger." And the uses of anger, which she first gave as like a plenary address at the National Women's Studies Association conference, basically is basically speaking to white women. So she's addressing white feminists whom she considers to be her sisters, her allies. And she's saying, look, you have to stop being so defensive. When Black women express their anger about social injustice, and they get angry at you for what you haven't done or the ways you're not hearing them, don't flee into guilt. Like, you get so scared of Black feminist anger that you're no longer able to hear, right? Instead, like Lorde is saying, you got to stay with the anger, right? In this instance, she's saying to white women, stay with the anger, listen into the anger of these Black feminists with whom you want to be in solidarity, right? Don't flee from it. And don't flee from it by fleeing into guilt like, woe am I, I'm such a bad white person. That is just the narcissism of whiteness, right? Instead, from within anger, if we can stay in it, and here in it, actually, I mean, this is the language, like a calling in rather than calling out. You're not being canceled when someone expresses anger to you, right? This allows the possibility for kinds of solidarity that's going to be hard fought, but this is the ground of accountability. It's not cancellation. I think we conflate the, you know, the, a calling out of racism, of homophobia, transphobia, of sexism. Like, this is not the same thing as cancellation, right? Also, who has the power? Like I have the power to cancel, you know, I could just go through a laundry list of Republican legislators I would love to cancel, as if I could, as if my little Twitter is canceling them. No, they just get bigger paychecks when they go to give a speech at a right-wing, at a right-wing think tank.
I think we have time for one more question, and then I'll bring us to a close, and would love to hear maybe one last thought you want to leave us with. But this is coming from actually a dear friend out in Oklahoma of mine. It says, lovely and provocative talk. Is there a provisional definition of trauma that you would suggest as we attempt to ward off the vulgarization of trauma that you rightly identify in the trauma of blows to self-esteem? I mean, it's true that the word trauma is thrown around so much, as you indicated, and as George here is asking, it's become something that we, the lowercase t thrown to anything. And so, what do you recommend in terms of how we understand that term?
Yeah, I mean, it's so ubiquitous that it's actually, what we need actually, and there are people who've done some of this work. I'm thinking of the book, The Empire of Trauma, for example. It's like a multifaceted genealogy of trauma that and how it's circulated from different kinds of sites. So in some sense, I can't answer that awesome question. I will not presume to offer a definition of it. And this, I suppose, is, I will think with my Foucault hat on, rather than with my clinical hat on, that I'm interested in the multiple sources through which we have this contemporary category of trauma. We know that one of the early sources for the development of trauma, the diagnosis of trauma, was actually insurance settlements to deal with workplace accidents and also to deal with railway accidents. So trauma first emerges as a way to think about, what do I owe to this worker who's injured on the job? What do I owe to the passenger on the train? So trauma has, one of its origins is actually the question of how much you're going to pay and who deserves it. It also has a history in the prosecution of war and the question of, what do we do with these recalcitrant soldiers, right? So I think we want to tell this multiple history. And to think about now, it's sort of floating in this way, is as if everyone deserves their own trauma. It's like and if we don't get to have a trauma, then we've been denied something, which it seems there's no historicity. Whether for the individual, even, we're all like flat surfaces of what happened on our media stream this day, right? We've lost the historicity of the individual, a historicity that involves others as well as their own otherness. We've lost the historicity of culture in a deep way.
Thank you so much, Ann. Beautiful talk and wonderful engagement from the audience. Thank you for that. So as we bring this to a close, a couple things really quick. Much like you did, I'd like to thank Mookie and Darby for the behind the scenes tonight of bringing this all to bear. It's so wonderful that the village can come together and be able to bring this to the world. Also want to just say that Ann puts on the occasional workshop for us to be able to go deeper into this. So you can spend a few hours with Ann actually doing Foucault on power and sex. So we'll throw this into the chat right now. If you would like to sign up, this is going to be in the winter time. And so we'll throw that into the chat now if you'd like to sign up. Again, any opportunities to hang out with Ann is always a good thing. So as we bring this to a close for tonight, Ann, what would you like to say? What are these last couple things you'd like us to take away and bring with us into our tomorrow?
Yeah, I guess it's just amazing. I'm so grateful for the conversations you're producing. I'm happy to be part of it. And I just feel like, the more conversations that we're puzzling over and slowing down, and I'm so hungry for it. So I'm just really grateful to have had this presentation forced me to do some more thinking through the sort of strange, puzzling ways in which self-esteem is floating around. And so basically, just let's all keep talking and listening, maybe listening more than talking, some of us especially. I talked a lot tonight.
Well, your hunger for all this is infectious and calls us to it as well. So thank you for that, Ann. Everyone have a lovely evening, and we look forward to being all together again in due time. So blessings, stay safe, and be well. Good night.